here is that vetting has not been made a condition of service or a prerequisite prior to actually appointment. And that is what we have been actually engaging with the DPSA about, to say in certain instances, especially in those categories that we have prescribed, part of the conditions of service or prerequisite for actually being appointed in this post, it must be indicated that you will be appointed subject to you having gone through or successfully gone through a security competencies test. As it stands, the deficiency is that it is not prescribed as a condition of service or a prerequisite, which is an engagement that we are having with the DPSA. Thank you, Chair.
I think before you go to the ADG, at cabinet level, we have taken a decision that nobody from now on will assume a position of responsibility when the vetting has not completed. So we go at because of sometimes the delays, we get to the provisional vetting and then say to cabinet, you can go ahead with the appointments. But even that, as it may, cabinet always, in those positions that are appointed by cabinet, always make a condition that the appointment is subject and conditional to the necessary qualification verification and the security clearance certification. And people are able to lose their jobs if they fail the security clearance requirements, even if they've already been in the position, if they're in those prescribed positions. But we have taken, I'm sure you have heard when it's just that we can't, for this purpose, is talk about specific positions. There were it was sensational in the media. There were allegations that we are refusing whoever to be appointed, which is not true. We're just completing our security competence assessments with those individuals, but that is the procedure now. The worry has been the delay or the backlogs that were on our part, which was caused by the absence of cooperation and submission of essential documents. And we have demonstrated that if everyone who has to be assessed completes the necessary documents on time, we can then move with speed and complete the assessment. So we are moving towards what you are articulating, Chair, and I'll hand back to the DG to deal with the remainder of the question.
Hoping that screening and vetting, according to me, those are two different things. So we're talking vetting here, not screening.
We are talking vetting, Chair. Last week, I even wrote to the DG to indicate that any department who wants a security clearance or assessment of a person and they request a screening, she must then write back to them and inform them that we don't do screening, we do vetting. That clarity is there as well.
Yeah.
Okay. And Chair, if Section 2.8 then must replaces may, remember there is also a section that includes applicant. Would it be correct to say successful applicant must instead of, so if I apply, whether I'm going to be appointed or not, it means therefore it's a must that I must undergo vetting. But it becomes much easier if I'm a successful applicant. It says those that are employed by or is an applicant. So it caters for those that are employed, and it also says if you are an applicant. So I'm asking, will that meet the constitutional matter? Imagine if there are 200 applicants.
Can I go back to the activity? The one that
yes.
You are still on.
Perhaps I could say that when, of course, a person is applied for a job, right, and becomes successful, then you are informed, even before you start, in the process of the HR negotiations. So if it is a condition then you would have been notified that your appointment is subject to. Then the point is clarified, and the person will then understand that for me to successfully be appointed into this position, this is the process that I'll be going through. And of course, vetting is an ongoing process, it's not a once-off thing. So we will continuously be looking at people's competence from time to time, because you have to go through revetting in any way. So it's not that once you've completed your vetting and appointment, it ends there. So it's just perhaps important for me to highlight that part when it comes to vetting. I wanted to really respond to the expanded definition of the security assessment and security competence, and the reason why we added the aspect that talks to with a view to detect threats to national security, because that becomes basically the only thing that we've added in the definition. And what we're saying here is that over a period of time, we have assessed that there's been this expansion in terms of threats to national security. And this is not limited to persons who are only having access to classified information, access to critical infrastructure, but it also includes persons or institutions or persons who are also in institutions that would then become persons of interest in terms of our definition thereof in the bill. So these are people that we will consider as people who are persons of national security interest, and that is defined in the bill. That is why we then added the insertion at the end, that as we do this assessment, we also have to determine one's competence as it relates to him or her or institution posing a threat to national security. So that's the reason we added that. I must add, perhaps by way of example, that we do from time to time receive requests even from our other agencies, our counterparts that we have bilateral relations with. They will send requests such as, we have this particular individual who wants to do business in our country, or a company that wants to do business in our country. And the reason why they will be doing that or requiring us to do an assessment of that person is primarily to protect their own national interest. So they would be wanting to know about that particular individual. So from time to time, then we are required to do a bit of due diligence on such individuals. I would also add that honorable members would recall there was a year where we were required to do a vetting of people in the supply chain. And that came as a result of an assessment by government that there is this particular threat that we are observing, and it relates to corruption. So in that regard, we were asked as the agency to start looking at conducting this vetting on these individuals who happen to be in this particular category. Doesn't really mean that the individuals that we were really vetting at that stage really we're vetting them only because they had access to critical information or as such, but it was because we realized that there was this increasing level of threat, which was a result of threat to our work as government. We furthermore say that in terms of 4.B, this will then empower the agency in a prescribed manner to access information that is reasonably required, which is in possession of or under the control of a Department of State or statutory body, regardless of any law to the contrary. This is already approved, or it is already in our statute. If we are able to do this, we would also then be responding to some of the aspects that we raise in terms of our definition of national security. I would want to use an example that all of us are faced with when we talk about the threat of terror as an example. You wouldn't really, one way of responding to such, you have to determine, if I were to use an example, here's a particular company or department. The department is giving a contract to an entity outside. If that entity, if we had been able to do an assessment of that entity, perhaps would have been able to detect whether that entity has any other links with any other organization or any other foreign entity or any other organization that could be posing threat to our national security. So it becomes important for us to do this part of assessment, which honestly is just about determining whether that institution or individual poses any threat to national security of the Republic. Thanks. I will then, Minister, I will hand over to Mr. Jafta. We'll be dealing with the bulk interception, which was the next question that was raised by members of the House, of the committee.
Thank you, Acting DG Minister, and afternoon to the Chair and the members. Just to foreground the issue of bulk interception. Intelligence agencies generally spend a bit of time scanning the environment. In this particular case, I'm just going to talk about scanning the environment in the foreign dimension, in other words, outside of the sponsoring country. And that scanning of the environment is various methods are used, including platforms that are technology-based. There's a distinction between scanning the environment and targeted gathering of intelligence, whether by human sources or using technology to acquire intelligence. Typically, targeted interceptions happen within the territory of the sponsoring country, and those are underpinned by the safeguards that members have referred to. A designated judge will authorize for a limited period of time and all the other safeguards. Bulk interception in the main happens outside of the boundaries of the sponsoring country, and it happens principally for purposes of scanning the environment. Now, there are various tools that are available that are technology-based for that purpose. You may be looking at radiation signals, electromagnetic signals, you may be looking at optical images, and then you might be looking at communication signals. All of these are important for purposes of scanning the environment outside of your country. So what we are really asking for is an enabling piece of legislation so that this can be done. I'm making the examples so that we can appreciate that we're not just talking about communications, we're talking about images, we're talking about radiation, we're talking about a whole lot of things. Many of them will overlap, look at weapon systems that are deployed, etc., etc. I can make an example. Optical satellite imagery will look at a particular piece of environment. You have baseline information. There's a country that's constructing a deep sea water port, and then you do an interpretation of that image to determine, okay, this is useful enough for commercial purposes. But once there are certain dimensions and characteristics, when you analyze the image, then you can say, but this can actually be used for military purposes. Then once that determination is made, only then now do you go into deep targeted investigation using other intelligence methods to verify what we're talking about. So all we are praying for is give us which is what the Constitutional Court judgment says, that we need to have an enabling instrument for this particular activity. By all accounts, it needs safeguards. And this is what the minister has alluded to. The Inspector General, whether on a continual or continuous basis, must exercise oversight and superintendence over this matter that most definitely can be and should be inserted. Whether it is in regulation, that's a point for debate. And who approves those regulations as a matter of safeguard, that is for debate, whether it's the legislature in the form of the JSCI or it's a member of the executive. And then when it comes to communications, you can have other safeguards if you pick up information that you reasonably believe involves South African abroad. Then you can have other safeguards in respect to that. I then want to come now to the issue of RICA, the question that was raised. The RICA principally addresses itself to interception of communications in a targeted fashion within the boundaries of a sponsoring country. I won't repeat the safeguards that I alluded to earlier. That is what RICA focuses on, principally to support law enforcement initiatives. So the bias with RICA is in respect to law enforcement. Yet on the other hand, the domestic intelligence services have to contend with other threats and risks that come from activities of foreign intelligence services, and very importantly, in the world of today, from non-state actors that they have to act against within. And so the legislation that the minister was talking about that will be coming before the committee will be intended to tightly regulate, but giving enough latitude to governing the aspects of domestic targeted intelligence operations. That's one dimension. The other dimension to it is there are softwares and technologies that are very portable and very useful that are accessible to everybody, including non-state actors, where interception, corrupting your phone so that people can get your data and all of that, these are there. One would imagine that the bill would also put in place measures that are intended to govern that and to make sure that appropriate censure attends non-state actors in particular who employ such easily and commercially available applications, software applications for purposes of intercepting information. So that is, in a nutshell, what the distinction between the two chair will talk about. When it comes to the topic that was the committee spent a bit of time, usefully so, on impede and neutralization. The point was made that this must be done in a prescribed manner in accordance with the Constitution and the law of the Republic. So in other words, there will be no measure, activity that will be instituted to disrupt an activity that poses a threat to national security that falls outside the boundaries of the Constitution and the law. In other words, no torture will be done, or let me say, before I go into possibly exclusionary factors, everything must be done within the Constitution and the law. That's on the one hand. On the other hand, it is not intended to invest by any means the agency with a mandate it otherwise does not have expressly provided for in law. So the agency has no mandate to effect to apprehend anybody, and therefore apprehending a person by the agency would immediately become illegal, and therefore it would not be a measure. What is one talking about, and will illustrate the point about why it is difficult to list a register of measures. We all know about how the famous case of a non-state actor in the United States was neutralized by determining that there were falsehoods with filing earnings with the relevant revenue authority in the United States. So it's not the intelligence that will impede or disrupt the activities of that famous underworld figure in the United States. It will be the revenue services. So you have instances where the disruption is not in real terms effected to or given effect to by the intelligence agency, but other entities in the state will effect the disruption. So in a sense, if X we know is in the business of trafficking in drugs, we can tip the Metro Police to mount a roadblock. They mount a roadblock, is a check of a vehicle, they find a large sum of money or that sort of a thing. We've disrupted that activity. So you are not going to see a member of the domestic agency actually doing the disruption, but the disruption is done in accordance with the letter and the spirit of the law. I thought I should pause there without over elaborating. And already it is already in the 1994 the Principal Act, the National Strategic Intelligence Act. I'm just elaborating, but I hope that the distinction between targeted and bulk interception suffices. Thank you, DG, Minister, and Chair and members.
Thank you very much. Good early evening, Chair, committee members, Minister, Acting DG. I'm going to be speaking to the issues of autonomy of the OIGI and NCOP and the ring fencing of the budget, responding to concerns raised by Honourable Kola Barnard and the question by Honourable Khadebe that this matter requires careful focus and whether ring fencing of the budget and the appointment of staff is enough to get autonomy. And further, what are the safeguards to ensure that it is not dependent on the executive authority in office at that point in time? So to briefly recap what the Minister said earlier, noting that the high-level review panel did not recommend the creation of the OIGI and the NCOP as separate scheduled entities, as well as the realities of the fiscal constraints that will not allow for it, but with a deep appreciation of the issues raised by the two in relation to the matters of financial autonomy, etc. The model that the SSA is proposing is similar to that of how the National Treasury currently appropriates the SSA budget. The SSA does not get it directly, it's through Treasury, but we do not account back to the DG of Treasury. So we are proposing the same, that we are further refining the insertion in the draft bill, section 4C3D, after this morning's meeting and reflection, to be amended as follows: that the budget of the NCOP shall be appropriated by Parliament as part of the Secret Services account and shall be expended in accordance with the rules and procedures set out in the Public Finance Management Act 99, Act 1 of 1999. As it occurs currently with the OIGI budget, that's the approach that is being taken at the moment. So the allocation letter from National Treasury will indicate the funds that are earmarked for NCOP. NCOP will then have the autonomy to determine how this ring-fence budget is apportioned and expended. Financial reporting will be part of the South African Intelligence Agency report to National Treasury, as with the OIGI currently. The same, as I said, pertains for the Inspector General. With regards to the issues of the approval of organizational structures and appointments, both entities will be supported with functional elements of the processes by the reviewed shared services model that we are currently consulting with all the relevant stakeholders as part of the preparation of implementation of this bill process. This will ensure standardization of systems and processes, particularly governance processes, especially as it pertains to issues around appointments. As Minister also alluded to earlier, there's the issue of being player and referee. So this standardization will help across all the entities in the environment. The delegation of powers to appoint at different levels will be amended to align to the best practice in the public service, and in this process accords greater autonomy to both the NCOP and the Inspector General's office. So speaking specifically to Honourable Khadebe's concern, the above mechanisms that I've outlined will be institutionalized in updated regulations to ensure that it is minimally impacted on by any change in the executive authority. I thank you, DG and Minister and Chair.
DG, did I see a hand from next to you? Over to you, DG.
Yes, Chair. I think I'm becoming a veteran of sorts. I forgot one topic that I had been instructed to deal with, and it has to do with the binding effect of the recommendations of the IG. The point is that we submit where there's no dispute about the findings and the recommendations of the IG. There is no question those must be given effect too And the accounting officers have a responsibility to do that. The members of the executive and the legislature, as the oversight body, must ensure that that is done. Where there is a dispute, which is a matter at hand, then the minister should ensure that there is a common understanding and gives a directive about what must happen to those findings and recommendations. Where the dispute sustains beyond the intervention of the minister, the chairperson advised, then the committee is the final arbiter on those. We then pray that the reading of the word minister must also refer to the ministers of defense and the police who are responsible for the intelligence divisions, because the minister for the civilian intelligence agencies has no executive or authority over the intelligence divisions of the police and the National Defense Force, respectively. My apologies for forgetting that to the minister in addition. Thank you.
Just to add on that, Chair, our argument is that the current arrangement sustains and they suffice, because that's how we have been dealing with it. And we think our view is that Parliament, through the committee, has enough power to make the recommendations of the IGI binding. The committee instructs ministers to implement, and there's not been if there's a defiance, there's a parliamentary process to deal with the defiance of a minister. We cannot then say committees have failed, and therefore it will mean that the committees have failed to execute that which they are mandated to do by law. And we agree with you, Chair, the current arrangement suffices, and that's what has been pertaining both in the civilian intelligence structures, but also in the other intelligence structures through your instructions to the various ministers. Thank you.
I think you said you agree with me. No. I never said that. It was a clarification. I never said I wanted it that way.
We agree with your clarification question.
Okay. Is this still on the floor?
There's still a few other questions which were raised. We're now going to move on to deal with the question around why we opted to retain opportunity and remove potential opportunity. Thanks, Chair. I'll ask my colleague, Mr. Mantata, to respond.
Thank you very much, Chair and committee members, Minister, Acting DG, and the colleagues. In responding to the question raised by Honorable Konabalat and Honorable Khadebe and the Chair as well, around the retention of our understanding of opportunity and the removal of the potential opportunity. Perhaps before one responds to the question is to give a premise that it is our understanding that intelligence is an important instrument that seeks to assist government as an active agent of the state to exercise control over the threat, the risk, and the opportunities. And that comes in the context of where governments needs to make sure that it does the best of its people on the basis of the investment that it has made, the opportunities that it needs to take both in and out of the country. On the basis of that, we take note of the concerns that have been raised by members of the public that the definition on our understanding of opportunity has been regarded as broad and is actually been repeated equally by members of the ad hoc committee as well. On the basis of the concerns that have actually been raised, we have reviewed our submission of the definition as contained in the bill to reflect the following. We see it as the Republic of South Africa's socio-economic growth, security and competitiveness, viewed, of course, within the parameters of Section 198 of the Constitution, in which we envisage the principle of South Africa's national security, which is quite emphatic of the kind of a South Africa that we wish to see today, tomorrow, as well as in the future. Thanks very much.
Is that the insertion? What? Yeah. No, no, I was looking at him and he was not reading anywhere, and that's why. Okay, Acting DG, you are still on the floor.
Thank you very much, Honorable Chair. The other question that just came now in the afternoon, as raised by Chairperson, is around departmental intelligence as it relates to the work of foreign branch in particular. What would that mean and what would be the implication, the agency? And I'm going to ask Ms. Mashele to assist us in terms of responding to that question. Ms. Mashele.
Thank you, Acting DG. Thank you, Chairperson. In response to your question, with regard to departmental intelligence that the service would have to focus on, there are departments of state, there are organs of state whose mandate is to operate outside of South Africa in the areas of trade, international relations, in the bilateral sphere, in the multilateral sphere. And this is an environment where the foreign service would be operational. And that is the departmental intelligence that we are talking about. This would be meant to enhance South Africa's negotiating positions, to also forewarn on threats and also on opportunities that arise from such relationships. And it is an environment where the domestic service would not necessarily be operating, but we also submit that it would be very critical for both the domestic and the foreign service to coordinate in this regard, because whatever the foreign service does, we must always refer to the implications for South Africa, and the domestic service would also become critical in ensuring that where there are opportunities, those are seized, where there are threats, those are attended to in South Africa. Thank you, Chair.
I think it becomes clear as you explain. Don't you think you need to tighten it up so that it's specific? Because I'm told the law must be very simple for anybody who reads to understand. So with this one, might be a bit ambiguous to need to be tightened up so that there's no confusion on it. I think I'm clarified on that one. You are still on the floor, unless if that was the last question.
Thank you, Chair. That was the last question from our side. Thank you.
Okay, Honorable Kola Barnett, followed by Honorable Adebe with an A.
Thank you, Chair. This through you. This is to the Minister. I'm going back to the first statement that she made, which was to clarify. She says that the document that was written about, we all read the op-eds and the articles, and the churches immediately started approaching us saying that they're going to make us get security clearance certificates. So it was out there. Is the claim that that was not the document that was lodged in Parliament and then sent back and declared to be unconstitutional and asked to remove those entities? That's how I believe the process had worked. Is the Minister now saying that's not what happened? Because when it was lodged in Parliament initially, we didn't see it for some long time. And then eventually we did, and those phrases have been removed. So I'm quite curious as to how the actual process went out. I mean, that document had been written and that document had been released somehow. I'm not interested in who leaked it. It's not my problem. But it did exist. So I want to know if that was the same one that was lodged in Parliament initially. Thank you, Chair.
Honorable had only one question.
Just one check. Let me choose which one to take. Okay, I'll leave the powers to appoint both NCOP and let me deal with the safeguards of bulk surveillance. So if I understood, come again?
Interception.
Oh, yes, yeah, bulk, you're correct. Thank you. If I understood you correctly, the safeguards as it relates to RICA might not necessarily be completely applicable to bulk interception, because you're not only dealing with communication, there are other factors involved. As such, what you are proposing suffices. So, because the follow-up question that I would have asked was, why then don't you copy what's contained on the RICA in terms of the interception charge and other verified, but you've responded clear. So I just wanted to get the fact that, is my understanding correct based on your response that not what is entirely contained in RICA might be applicable based on the nature of the bulk survey? You don't only dealing with communication. And if I heard you correctly, then I think I'm neutralized, Chair.
Can I just say, can I just say on the question that was, or on the clarification that was sought by Honorable Kolabanat, there was a flurry of questions from the media that came to the committee, but we couldn't answer those questions. And then even in the public participation process, we kept on saying we only deal with what we received. Parliament has never seen that document. I mean, even if I saw a copy, but that was not Parliament. What we deal with is what Parliament, it goes to the Speaker and the Speaker takes it to the committee. But such a document never reached the committee. So what we have is what we are dealing with now. But maybe Honorable Kolabanat wants to understand how you work your things in there. Was the document from, but not that she's questioning what we are dealing with. Maybe your processes, or was it leaked? Was it drafted from the department or whatever? That is the process issue, but not, we are not discussing that document. We have never seen it.
Thanks, Honorable Chairperson. I can only account of what I tabled to Cabinet for Cabinet's approval, which is the document we submitted to Parliament, which is the document that was then given to the committee to process. The other things of what happened were, it's a process issue. Can I be allowed to say it's a process issue, but the document we submitted is what eventually got submitted, passed on by Parliament to the ad hoc committee to consider, and we leave it. We leave it there. And maybe before the honorable Pardon my the lateness I'm making, Mr. Jaftra, an honorable member.
He seems very happy about that.
He will explain, but Honorable Hatebe, it's for domestic purposes. And then bulk interception, it's for foreign. And then, no, the safeguards for foreign, we operate in a different world. The safeguard is to make sure that bulk interception does not take place domestically. And we've proposed the safeguards. And we're saying, the question you're asking, it's advanced, it's ahead of the time when we bring the targeted interception and surveillance bill that we're proposing through the OIC. You'll then say, how does that and RICA differ, the complementarities and the differences? That's what it is. So what we are requesting is how we deal with ourselves outside the borders of the Republic. And your safeguard is to say the Inspector General will ensure on a continuous oversight and reporting both to the Minister and the Standing Committee that the audit, or what do you call it? Yeah, for lack of a better word, they'll do oversight to ensure that bulk interception activities are never deployed domestically. Yes, thank you.
And maybe, I think you have answered your questions, all of them, when I check my time. Maybe a comment. Yeah. Yeah, maybe I didn't want to remind them because they were the ones that were talking anyway. So maybe there was supposed to be what is called an evaluation. Is it an evaluation committee? It was never established. And according to my understanding, it has got some powers to go operational. And it must be established by the president. I'm not sure where the Minister of State Security gets into. And if it has got operational powers to get into operational issues, it would help. Unless if maybe the agency don't want it to be established because it will look into some of the things. I don't expect you to answer to that, but maybe when you meet the president, you must ask her, why was this never established? I'm not sure whether it's our job to ask the president or maybe it's your job. Okay. I wouldn't allow any other when I check my time. We are already 15 minutes outside your time as you requested yourself. Thank you very much. I think you all know the process from here. We're going to deliberate on. And can I thank you for the responses, because the problem might be in the semantics, but the content, as you explained, it makes sense for people who are going to draft. That's why maybe you might have written English instead of legal terms. But now at least we've got an idea of what do you want to say here and there. Thank you very much, and the meeting is adjourned.
Thank you, Chair.